to Winning Isn't Easy. Let's talk about the secret to getting your own occupation disability benefits. Now, if you've got an ERISA disability policy and your doctor has told you to stop work, one of the most important steps you can take before you stop work is to read that policy cover to cover before leaving the job. You are going to see two standards of disability. One, generally for the first 2 years, is an inability to do your own occupation, and ultimately the definition is going to change to any occupation. This is often where people get blindsided. Just because a carrier has accepted your own occupation's claim doesn't mean they're automatically going to continue to pay those benefits when the definition changes to any occupation. So I want to talk about the concept of sedentary work. Sedentary work is a term of art used primarily in Social Security cases, and it's based on the Dictionary of Occupational Titles definition. And basically, it's you can't sit more than 6 to 8 hours, limited standing, limited ability to sit, the need to change positions. And it also involves, by the way, non-exertional issues such as the need for breaks, difficulty with pace, the difficulty with with stooping and bending, but also other postural limitations and the use of a person's hands. I want you to be thinking about the whole constellation of your body, if you will, at both the own occupation stage and the any occupation stage. Now, when you get out your disability policy or plan, you will see that it may have a definition of occupation, and you need to understand what that is. Is it the occupation you are doing for your employer in the local economy, the national economy, pursuant to the Dictionary of Occupational Titles? And you might want to get your own employer's occupational description. Why? Take that apart and think about not only why you can't do those occupational duties, but specifically, if there's anything sedentary about your occupational duties, you want to start documenting in your medical records why it is, even at this point in a own occupation period, that you can't do or have difficulty doing sedentary work. Remember, lifting no more than 10 pounds, occasionally carrying light items like files and tools, primarily sitting, standing or walking is no more than 2 hours in an 8-hour day, 6 hours seated. Now, I want you to be thinking about that. So let's say, for example, you worked for a company and you were a traveling salesman, okay? So obviously that requires you to put together presentations. It requires you to do presentations. It may require you to travel by car or by plane. And so there is some sitting involved, isn't it? You want to be emphasizing all the reasons why you can't do that occupation, including focusing on the sedentary aspects of that. Remember, if you can't lift even 10 pounds, if you can't stand or walk more than 2 hours a day, if you need assistive devices, if you can't sit more than 6 hours a day, if you have to alternate between sitting and standing, you need breaks, if you have postural limitations, problems with your hands, problem with focus, problem with absenteeism, all of these things can erode your ability to do not only your own occupation, but when we get to the any occupation game, help you. Why do I say game? Because at the any occupation stage, the carrier wants to prove up that you can do any occupation that's of a sedentary nature. If you can sit, you can work, and they don't think you are disabled. It's as simple as that. Now, sometimes as we approach this change in definition of disability, I think about getting an FCE, and that can be done, a functional capacity evaluation, before the definition switches, or if you get an inkling that they're going to deny your claim, or you get a denial letter. The FCE objectively measures your ability to perform work-related tasks, and it can be the difference between staying on claim and having your claim denied. Now, I like to use reputable vendors, and I want my treating physician to review and endorse it. We want to see this consistency between what's in your medical records and the history of your symptoms and functionality and your FCE and what you've told the carrier. It's not cheap, I will tell you. And it's not cheap because it can cost $1,000 or more, but it can make the difference between what happens in your claim. The other thing that you need to understand is, look, when you're applying for Social Security disability benefits, and you're required to do so in ERISA disability cases, Social Security uses a 5-step sequential evaluation. And at step 4, the issue is, can you go back to the lightest job you held in the 5 years before your claim was adjudicated? Sounds a whole lot like own occupation, doesn't it? But where those cases are won and lost is step 5. And that test is there other work in the mythical, hypothetical, not real world national economy that you wouldn't want to do and that does not pay a living wage in view of your age, which is not a factor in an ERISA case generally, your education, the skills you've learned, and your restrictions. Sounds like some of the things I've already talked about. In the Social Security world, it also comes down to a question of whether you can do sedentary work. Now, many times in Social Security, they'll say you could be a surveillance system monitor, you could be an addresser, you could sort nuts and bolts. Disability carriers are more sophisticated in finding other sedentary type jobs, but that's the game, okay? And so what will happen sometimes is that the disability carrier will say, hey, the definition just changed, and, we think that you can do any kind of occupation, and we're going to deny your claim. And about that time, you get the Social Security decision that says, not only can you not do your past work, but you can't do other work, we're going to pay the benefits. Now, you may think that that's all you need to win your any occupation claim, and it's not. And it's not because age is not a factor. But 2, what you will see is there are 2 ways to be disabled at step 5 for Social Security cases. If you're over 50, the judges may use something called the grids. And disability carriers will say, well, they gridded out based on their age. That means nothing in terms of their ability to do their own or any occupation. Or the judge may have found that your exertional skill level is light, but that there's been an erosion of your ability to do that. And by the way, you're disabled. Well, a disability carrier is going to seize on that finding that you were able to engage in light work and deny the claim at the any occupation stage. If that happens where we've got this whipsaw, clearly we want to, if possible, get a functional capacity evaluation that will clarify the functional, physical, exertional and non-exertional restrictions and limitations, so that ultimately our own vocational evaluator can attack the disability carrier plan's denial of the claim based on their doctor's opinion about your ability to do at least sedentary work, and their vocational evaluator's opinion about all the bogus jobs that allegedly exist that you would be qualified to do based on those restrictions and the transferable skills. So we want to be prepared to attack all this. I want you to be thinking about this from the very beginning. How am I going to use and comprehend the definition of disability and occupation to create the foundation for ultimately proving that not only I can't do my own occupation, but I can't do any occupation. So we want to be thinking about sedentary work from the beginning of the claim, even though your occupation may not be sedentary in nature. You can see where this takes a lot of planning and forethought. And what are the reasons why you should be considering hiring an experienced ERISA disability attorney? Because strategy and tactics can make all the difference. Now, in our next section, we're going to change tact, and we're going to talk about psychiatric disability claims and how that interacts with the own occupation standard and some pitfalls that can lead to a claims denial. Got it? Let's take a break.